Hi guys, this is the third and final video for the day, and this video is for discussing what what is a written statement. I'm so sorry guys, I've been having these coughs, that's why I'm getting interrupted by them in between, so please try to bear with me. Thank you. So I'll try to discuss and explain to you what is a written statement, what is the significance of a written statement, and what it means, and what are the laws, the provisions attached with written statement. So, guys, as I told you in my previous video about what is a plaint, well, written statement is something you in common language you may just consider it a reply to the plaint, but our profession is not so simple that we would be able to suffice with just common language. So taking that on that note, I'd start by explaining you what is a WS. So a WS is basically a pleading of the defendant in the answer of the plaint filed by the plaintiff against him. It is a reply statement of the defendant in a suit specifically denying the allegations made against him by the plaintiff in his plaint. The provision regarding the written statement has been provided in the Code of Civil Procedure, and that provision is Order 8. So, whenever you're drafting a WS or whenever you have to read anything about WS, always refer to Order 8 of the CPC. Now, again, WS has also not been defined per se in the CPC, but it basically means that it is a reply to the plaint which is filed by the plaintiff. In other words, it is a pleading of the defendant wherein he deals with the material facts alleged by the plaintiff in his plaint and also states any new fact in his favor or takes legal objections against the claim of the plaintiff. Now, who may file a written statement? Excuse me, guys. Who may file a written statement? A written statement may be filed by the defendant or by his duly authorized agent. In the case of more than one defendants, the common written statement filed by them must be signed by all of them. But it is sufficient if it is verified by one of them who is aware of the facts of the case and is in a position to file an affidavit. But a WS filed by one defendant does not bind the other defendants. Now, I know this point sounds a little bit confusing, so let me clarify it for you. So a WS can be filed by a defendant. All right. Suppose if I'm a defendant, it can be filed by me, or it can be filed by someone on my behalf. If I assign, suppose A to go and file a WS on my behalf, or if there are more defendants, like one defendant is B, then there's other defendant, there's one more defendant, A, B, C, D, and so on. So a common written statement on all the defendants' behalf can be filed, and it can be verified by just one single defendant who is aware of all the facts and circumstances of the case. But a point that you all need to remember is that all the defendants are not bound by the written statement which is filed by one defendant. All right, basically a WS filed by one defendant does not bind the other defendants. Now, limitation of time. So time limit of filing a WS is 30 days from the service of summons, and the said period can however be extended to 60 days as per rule 1 of order 8. A defendant should present a WS of his defense in the said period. Now, defenses in WS. In WS, a defendant can specifically deny the allegations made in the plaint by the plaintiff. I'll share my screen again with you, so it'll be easy for you all to understand. Yeah. So, in written statement, defendants can specifically deny the allegations made in the plaint by the plaintiff against him. Besides this, he can also claim a set-off of any sums of money payable by the plaintiff to him as a counter defense. This has been mentioned under Order 8, Rule 6. Further, if the defendant has any claim against the plaintiff relating to any matter in the issue raised in the plaint, he can separately file a counter claim along with his written statement. It is provided in Order 8, Rule 6A to G of the Code. Particulars of a WS have been mentioned in rules 1 to 5 and rules 7 to 10. Carefully look at these provisions. These are very, very important and useful provisions. These are special rules of defense, guys. Like the rules which you need to follow while filing a WS, like new facts such as the suit not maintainable or that transaction is either void or voidable in law, and all such grounds of defense would take the plaintiff by surprise. Like anything which would take the plaintiff by surprise is not allowed. All right. Uh, Denial must be specific. It is not sufficient for a defendant in his WS to deny generally the grounds alleged by the plaintiff, but he must deal specifically with each allegation of fact which he does not admit except damages. This will be more comprehensible once I start discussing the format of the WS. So give it a read to this, guys. The denial should not be vague or evasive, where a defendant wants to deny any allegation of fact. Sorry, where a defendant wants to deny any allegation of fact in the plaint, he must do so clearly, specifically, and explicitly, and not evasively or generally. You will find many such WS where the parties or the advocates are just vaguely denying everything that has been written by the that has been mentioned in the plaint. In fact, very recently during my physical internship at Lexis and Company itself, I encountered one such WS where the advocate had literally just answered the similar things. Like we had filed an injunction suit, and in reply to that injunction suit, he had literally mentioned the same things over and over and over and over again. So sometimes it also happens that when you're drafting a replication or when you're drafting a reply to such WS, you also tend to get frustrated because you have to go through the same things over and over and over again. All right. With that being sorry guys. With that being said, let us just move on to the format of the WS. Yeah. So facts are mentioned below. First, let me close this ad. Sorry. Yeah. An aged widow about 80 years, is the owner of immovable properties in Hyderabad. She has a son B who was having a wife C. All are Indian Christians. A is purported to have executed an irrevocable indenture of settlement by which the income of all the said properties is supposed to have been given over to B and C. C has filed a suit against A and B for carrying out the provision of the said deed of settlement. She has also alleged in her plaint that the income, possession, and management are denied to her. A wants to contend in defense that the said deed was brought about by B and C under influence and misrepresentations, that neither the possession nor the management was ever handed over to B and C, and the said deed was never handed over upon, and that she is still the sole owner in possession and management of the properties in suit. So again, you will mention the court's name, suit number, this, details of all the parties. Yeah, details of all the parties. Defendant number one, above named, states as follows: that they admit execution of the C. So all the true facts and material of record are to be admitted by you, but you have to paravise counter all the claims of the plaintiff. All right, like this. On 9th April, the plaintiff and different, and of course, yeah, if you have any new facts to add, you can also mention them in the WS. So this is the format. Excuse me, guys. Uh, this is how you draft a WS. This is the body of the WS. All right, you mention your facts as you mention the body. You draft the body of the WS as per the facts and circumstances of the case. This is the prayer and counterclaims. After prayer, date. name of the advocate, defendant number one will come at this side. Actually, here the signature will come. Don't worry guys, I'll share a proper format with you on the Google Classroom. This is just for your sake of understanding. Do not follow this format strictly. All right, I'll send a proper format on the Google Classroom. And yes, you have to attach a verification and affidavit with a WS as well. uh, Yes, that is all with regards to written statements. It is not such a complex thing, guys. You all, I'm sure, are competent enough to easily understand what is a plaint and what is a WS. And once you go through Order 7 and Order 8 of Code of Civil Procedure, you'll easily get through everything, because then you'll have an idea about what I'm trying to discuss with you here. And again, the tasks attached with this videos are same. Either you can make a sample WS, or you can write an article about written statement. You can find me around 10 to 15 or 20 articles with regards to WS, then it'd be great. Actually, I would like you all to find out around 15 to 20 articles with regards to all the topics I mentioned: uh, divorce, the mutual divorce petition, plaint, and WS. This is for those of you who do not wish to draft a sample WS. All right, and it's not necessary that you yourself have to sit and write those 15 or 20 articles. You can just proofread around 15 to 20 articles from different sources, paraphrase them a little bit, and send them to me, and we'll post them on our website. And of course, if you write your original articles, then we would surely keep that in mind and display it on our website from your name. Soon we'll make you contributors to the website, so that you can you yourself can easily add content to the website. Or yeah, that is it. But and yes, guys, do remember that you do not have to you do not have to write the sample drafts or the articles on all the three topics. Choose any one out of these three, either the mutual divorce petition or plaint or written statement. All right, so that would be all for today, guys. And of course, if you have any doubts with regards to this video, then post your doubts in the comment section below, and we'll get back to you with all your queries. Thank you so much. I'll be signing off for now, and have a good day. Thank you.